Host Ilyas Bulbulia, and I'll be with you for the next hour. As our regular viewers are aware, on Just Law we normally discuss an area of law which may be of interest to you, our viewers. Normally we discuss matters relating to immigration law, about how to make spouse applications from abroad, how to extend visas in the United Kingdom, how to apply for nationality, etc. But more importantly, in addition to discussing an area of law which may be of interest to you, more importantly, it's a live show. So you're able to pick up your phone, give us a ring and ask us any questions that you have on any aspect of English law. On this show, we should be able to cover most areas of law, not just immigration law. So if you've got a query which extends to, let's say, family matters, criminal matters, personal injury matters, etc., it's not a problem. Do pick up your phone, give me a ring and we can have a discussion about it, and hopefully I should be able to give you some firm advice in relation to the question that you have. Just a couple of points before we get going. As always, because it's a live show, we're not able to look at your documents before we give you advice, and if it's necessary for me to look at your documents, I'll ask you to leave your number with the control room, and then I will give you a ring back and I'll ask you to send your documents over to me, and I'll have a look at the documents and then advise you further. And secondly, obviously, because it's a live show, we're not able to take very detailed instructions from you. Obviously, I can only take a certain amount of history from you. If it's an immigration matter, for example, I can't take too many details because it's a live show and we don't have that much time live on air. And if it transpires that I do need to take a lot of history from yourself, then I will ask you to leave your number with the control room and we can have a more detailed discussion later on about that. But in my experience on this show, I should be able to deal with the vast majority of questions that you, the viewers, ask without looking at your documents and without needing to take very detailed history from yourselves. I should be able to give you quite firm advice live on air. So whatever your questions are, please do pick up the phone and ring us on the number that appears at the bottom of your screen and we can have a discussion about your query. So that's the introduction out of the way. As you'll be aware, over the last few weeks we've been looking at different stages that a spouse application or an immigration matter where somebody is coming to the United Kingdom under the spouse category goes through. Previously we've looked at how to make a successful application for a visa for a husband or wife to come to the United Kingdom. We've then looked at extension applications. And today what I want to do is in particular look at extension applications for somebody who's already here with a spouse visa. So they've got their 2.5-year visa. They're already in the United Kingdom on that visa. And what the requirements are in 2.5 years' time when you come to extend the visa. And that's what I want to look at in greater detail today. Because ultimately what we want to do is go through the different processes after the extension. In another 2.5 years' time, the person in the United Kingdom would then be able to apply for indefinite leave and then ultimately apply for nationality a year later. But what we want to do today is look at the initial middle stage where the husband or wife, from whichever country they're from, they're already here in the United Kingdom and they are looking towards making an extension application, because obviously they're granted a 2.5-year visa, they need a 2.5-year extension to get to the indefinite leave stage. So that's what I want to look at today. But as always, as I've said at the outset, this is a live show, so whatever questions you've got, it doesn't matter if it's not related to this, do please pick up the phone, give me a ring, inshallah we should be able to have a discussion about that. Whether it's in English or Urdu, it shouldn't really be a problem. So let's look at the sort of background to this topic for today, the extension application which is made in the United Kingdom. That's obviously for somebody who's here on a spouse visa. They've already spent 2.5 years, or they're looking ahead to see what they're going to have to do in 2.5 years' time to extend their visa. And I think with immigration matters, it always helps to do a bit of forward planning, advanced planning, to bear in mind that, look, the visa has been granted for 2.5 years, but in the same way requirements had to be met when the initial application for a spouse visa was made, in the same way there will be certain requirements which will need to be met when the extension application is filed in 2.5 years' time. So it always helps to do some forward planning and to try and get things in order before hitting that 2.5-year deadline. Especially with spouse applications, because a lot depends on having your documents in order, which may relate to a time period 6 months before the application, or it may relate to a period a year and a half before the application is made. So forward planning is essential if you want to make a successful extension application, for it to go through straight away and for there to be no hiccups at all. The main issue in extension applications, in my experience, and this is what causes the majority of the problems, like we have problems at the spouse application stage, we have the same problems at the extension stage, and it's a problem with finances. It's how do you meet the financial requirement, like you met it at the spouse initial stage, how do you meet that requirement at the extension stage? And I think that's where the majority of the problems lie. So I want to look at that in a bit of detail. Then we can look at the other requirements, such as the requirement that there should be adequate accommodation, the marriage is subsisting, etc. But let's focus on the financial requirement, because if you look at previous shows as well, the vast majority of questions that we've had relate to finances. How do we get the finances right so that there's a successful application? The starting point really is to look at, first of all, whether there will be a requirement to meet the 18,600 requirement or not, or whether it's going to be an application where, because somebody is in receipt of certain benefits, such as carer's allowance, disability benefits, etc., they will not have to meet the 18,600 requirement. So that's always the first thing that you look at. Is it the case where the full 18,600 requirement will have to be met? Or is it the case that we fall into an exemption and we don't have to meet that category? Let's look at the basis, or let's look at the scenario where the 18,600 requirement does have to be met. So it's not, we're not exempt from the requirement. Let's look at that. Once we've established that, what do we then need to look at? We need to look at whether the applicant and the sponsor, the husband or wife in the UK, whether that person is working or is self-employed. Because there are different rules which apply to somebody who is working as opposed to somebody who is self-employed. Fundamentally, what you need to bear in mind is the time period that the evidence will need to cover. For somebody who is employed, we only need to look at the last, generally speaking, the last 6 months wage slips, although there are exceptions to that. But fundamentally, in most cases, you're looking at the last 6 months wage slips. Contrast that with somebody who is self-employed. There you need to look at documents, normally for a period of at least 1 year, and that 1 year period may not necessarily even be the last 12 months, it could be the last financial year. So if somebody was making an application today in February 2018 to extend their visa, it's very possible that they will need to submit documents which relate to not the last 12 months but relate to the period April 2016 to April 2017. So we need to work out, first of all, does the minimum income requirement, the 18,600 requirement, does that have to be met? If so, what kind of work is this person doing? So what I said at the outset, it helps if we do some forward planning. The reason I say that is, in the example that I've given, where somebody is self-employed in their own little business, they're not running a limited company, it could well be that the documents that they submit relate to a significantly a period of time which is significantly in the past, and that's why it's important to bear that in mind. Let's take our first call for the day and then return to this topic. Hello, assalamu alaikum.
Wa alaikum salam.
Thank you for calling. What's your question?
Brother, my question is, I've just put my visa, I've got my wife over, she's over here now.
Okay.
But I'm out at work at the moment.
Okay.
And what's the next step I take?
Okay. Roughly, do you know when your wife's visa will expire? Do you know when it might expire?
Maybe, I think it's end of this year.
All right, end of this year. So we're looking at around December 2018. Do you have any children at all with your wife?
One child, yeah.
One child. Okay. And what's the possibility that you're going to be able to find employment? Do you think that's realistic, or that's not realistic in your case? Or?
No, it is. Shall I get him back into work?
All right. Okay.
But yeah, just wanted some advice.
Okay, no problem. Fantastic. Thank you very much for your call. If you keep on listening, I'll take you through the various options you've got available. But thank you very much for your call. Now, very relevant to the matter that we're discussing today. Now, visa expiring at the end of 2018. Visa expiring at the end of 2018. The sponsor is not working in the United Kingdom at the moment. In terms of whether he will be able to find a job, it seems to be quite debatable, and certainly from the sounds of it, it's not certain whether any job that he finds will meet the 18,600 requirement or not. Now, the good thing here is that although the minimum income requirement, the requirement that the parties need to be earning 18,600 has to be met by way of normally, if they are employed, by looking at the last 6 months wage slips for him, and if the wife is working for her as well, and they can both be combined. Now, if we end up with a situation that come December, the husband and wife, they're not working, or the minimum income requirement cannot met. They are working, but they're not earning enough money over the last 6 months, over the last 12 months. They're either not working or not earning enough money. The good thing here is that because there is a child, the Home Office will extend the visa in the United Kingdom, even though the strict requirements are not met. Now, I have to emphasize here that this sort of exception where the Home Office does grant a visa despite the minimum income requirement not being met really only applies, in my experience, where there is a child under the age of 18. Where the children have grown up, or where there are no children at all, the Home Office will apply the rules very, very strictly. So in this particular case, as far as this call is concerned, even if the financial requirement isn't met, the application should be made on time, either using form FLRM or FLRFP. Either forms are accepted by the Home Office. The application should be made, and all the questions should be answered. As many documents supporting the application should be submitted. Even if the financial requirement is not met, the Home Office will grant a visa. But there is a difference between the kind of visa that will be granted where the requirements aren't met, and between a case where the requirements are met. The difference is that in the caller situation, the Home Office will place the wife onto what they call a 10-year route to settlement. So unlike the situation now, where she is on a 5-year route to settlement, where she's got the 2.5-year visa, after another 2.5 years, she will qualify for indefinite leave. So there's a 5-year route to settlement at the moment. If during that time, and it's likely that in December, when the application is met, the rules won't be met properly. So what will happen is, instead of the 5-year route to settlement, she will be placed onto a 10-year route to settlement. So it will take potentially 10 years for her to be able to qualify for indefinite leave to remain. But the good thing is that the application will be granted. Just before going back to what we were discussing, I think it's important that where there are no children or the children have grown up, it is absolutely essential that the parties do try their best to try and ensure that the rules are met. Because what is happening at the moment is that where the rules are not met, the Home Office will refuse the application. Now, the only positive thing to come out of that refusal is that the Home Office will grant a right of appeal. So ultimately, the judge will end up deciding whether the applicant, could be the husband or wife, whoever's come from abroad, whether they should be allowed to continue to live here despite not meeting the requirements. And I suspect not many of these cases have gone to court yet, but I suspect that what the court will look at is how far off are they from the minimum income requirement? Why is it that the rules haven't been met? Has something happened unexpectedly, like they're having to look after somebody, or somebody's become ill? So the judge will probably look at why it is that the minimum income requirement can't be met. It could be that somebody's found a job recently, and that's why the requirement over the last 6 months' wage slips can't be met. But what will happen where there are no children is that the application will be refused if the financial requirement can't be met. And ultimately, because there's a right of appeal, the judge will decide whether a visa should be granted or should not be granted. And I personally think, knowing people who have been in that situation, I think it's a very difficult situation to be in because you're literally in the hands of the judge. By the time your hearing comes round, you've lived in the UK for 3 years and you're facing the prospect of having to go back to your home country. And obviously you're able to come back, but you're looking at the prospect of having to return back to your home country and for the sponsor in the United Kingdom to make a fresh application again to sponsor you back to the United Kingdom. And I think that's a very difficult situation to be in for anybody. The sort of upset to somebody's family life, etc., I think is enormous. But ultimately, if the application has been refused, you're basically in the hands of the judge who will decide your fate. And the difficulty I see is twofold. First of all, there is very little case law on how the judge should deal with this situation. It's seen as a human rights appeal. Very little guidance as to what the judge should or shouldn't do in that situation. So to some extent, the judge has a lot of leeway, a lot of flexibility. But the other problem is that in itself does mean that it's very difficult to predict. You could be before one judge who sees the case in a particular way, but also you could be before a more stricter judge, let's put it that way, who looks at the case in a different way and may have come up with a decision which is not favourable to the person appealing. So it's important that and it comes back to planning in advance, and it's important that documents, etc., are in place so that you try, if at all possible, to not be in this situation. So just going back to what we were looking at in terms of income requirements, the easiest matter is where somebody is in employment. Easy because all that requires is 6 months wage slips, 6 months bank statements and an employer's letter to be submitted. And that's assuming somebody has been in employment for the full 6 months. If it's the case that somebody has started a new job and they've been working for their current employer for less than 6 months, then that's not the end of the matter. There is hope. What the parties can do is show their income over the last 12 months and demonstrate whether the requirement is met that way or not. And because at the extension stage, both parties are able to work, obviously the sponsor is able to work being a British citizen, and also the applicant from abroad who's now here in the UK with a valid visa, the applicant's able to work, both their income their salary, etc., will be taken into account. So it could be 6 months' wages or the last 12 months' wages. Potentially, that can be taken into account. So to some extent, it's easier to meet the financial requirement at the extension stage because it does mean that both sets of salaries, income, etc., can be taken into account. Contrast that with the initial spouse application, where generally speaking, there are exceptions, generally speaking, only the UK sponsor's income is taken into account, and where all the burden effectively is on the UK sponsor in most cases to demonstrate that he or she earns 18,600 or not. And we know what the difficulties with that is, especially in places outside London, where you're doing, let's say, a more basic job, it could be that your income only manages to get to 15,000 a year, £15,500 a year, and you miss out on the 18,600 threshold. So at the extension stage, it's easier because you can show one party, for example, earning £14,000 a year, the other party, the other husband or wife, also working, and let's say working part-time and earning £7,000-8,000 a year. You can combine both and meet the income requirement that way. So in one sense, it's a much easier application to make when you extend your visa within the United Kingdom. So that's the situation where somebody is employed. Obviously, that's not always the case. You have people who are self-employed, and I think they're the more difficult cases, because it's in those cases where you have to make sure that your documents are ready well in advance. Where somebody is self-employed, starting point is which period should your documents cover. And where somebody is a sole trader, or they are a partner in a business, it's a partnership, they're not operating through a limited company, you have to show documents which cover the financial year, which is April to April. And as I was explaining before, if an application was being made now and the sponsor or the applicant, whoever it is self-employed, they've got their own little business, they're not operating a limited company, they will have to show their income from April to April. And if you're applying now in February 18, that would be April 16 to April 17. We'll discuss this in greater detail after we've taken our next call. Hello, Assalamu alaikum.
Hello, walaikum salam.
Ji, brother, thank you for calling. Ji, what's your question?
Yeah, my question is, my wife came to the country in 15th of August 2012.
Okay, all right.
And she needs to apply for indefinite leave to remain.
Okay, all right. Okay.
So I know there were recent changes in the for applying for indefinite leave to remain. So if you have applied after a certain date, I think it was in July 2012.
Absolutely,
but
yes.
But she was granted leave before that date, but she landed to this country on the 15th of August.
I understand.
2012.
I understand.
So what is the criteria for us?
The easiest way normally to work out whether the visa that's been granted is under the old rules or the new rules, the easiest way to work it out is to look at the length of the visa. Now, if she has been granted a visa for 2 years and 3 months,
yes,
she will be under the old rules. And I suspect from what you're saying that she has been granted a visa under the old rules, which would be a visa for 2 years and 3 months. Am I right in assuming that?
Yes, correct. I think she got. I'll still need to double check that,
Yeah,
but
yeah.
I think she was granted leave for more than 2 years.
Yeah, but I'm assuming it's 2 years. And has she extended the visa once already?
Yes, she has.
Okay. Now, and it may well be that she extended the visa because she didn't meet the English language requirement. Is it? Is that where the difficulty?
No. She extended because the visa expired.
Okay.
So the initial stage of the 2.5 years expired, so I had to apply for an extension. But I was told that the extension would have.
Why did you not apply for indefinite leave at that stage?
Because I was told that she would have to meet the criteria for the new rules, not the old rules. I think
so. She came to the United Kingdom in August 2012. That's what
correct.
You said. It's very likely that actually she's under the old rules. What would be helpful if you can? I need to go for a break soon, but what would be helpful is if you look at the initial visa and the length of the initial visa, okay?
Correct.
And if you also look at the extension visa that she's been granted and how long that's been granted for. If you just get those 2 periods for me, I don't know whether you're able to access, to see the passports at all or not from where you are in the next few minutes.
Yes, I can.
And if you then give me a ring back after we've taken a break, because I'll be able to work out what's happened. It looks to me like she could have applied for indefinite leave, and you might have been misguided. But let's see if you're able to get the initial duration of the visa, work that out, and what the extension is, and then let's have a discussion after the break. Thank you very much.